A non-binding death benefit nomination is a direction to a trustee to say, this is what I'd like you to do with my death benefits. Because once a trigger event of death takes place, it's generally up to the trustee of the fund. They have a complete choice as to where those benefits go within some relatively broad parameters under the superannuation laws. So that's not ideal for a lot of people. A lot of people say, oh, actually, no, I'd like to treat my super in the same way as I would treat my house. So with my house, I can have a will, and that will is going to direct where my house goes. Well, so too with my superannuation. You can't deal with it under your will for the way the legislation's crafted, but you can do something that's analogous to a will. You can do a nomination. And a BDBN, the critical part of a BDBN is that the first initial. So it's binding on the trustee. It removes the ability for the trustee to have a choice. The assets have to be distributed in accordance with that valid nomination. In some respects, the way you ask the question almost gives the answer, I think. I mean, the tip is that you do look at it very closely, that you consider it, and that you think about it in the context of both the trust instrument, the trust deed, or the rules for the SMSF, but then overlaying the factual matrix of the members and the trustees as well. So, you know, there is, I think in times gone past, this is gradually changing as people get more educated, but I think in times gone past, a lot of the sort of the general view in the marketplace was that everyone needed a BDBN. Everyone needed a binding nomination. My sense of things is that's starting to change as trustees start to think about the question that you just asked, that they realise that in some respects, the question of whether they need a binding nomination is almost more important than what the answer is. And the reason that question's so important is because it forces people to say, well, what does my trust deed say? What's my family situation? What am I actually trying to achieve under my estate plan? And then that feeds into a proper thought process around the merits or otherwise of doing it. I think so. Without hospital plussing, ask a lawyer. You ask two lawyers a question, you end up with three different answers. So you need to be a bit careful. And strictly, I think a lot of lawyers in the space would argue it is ultimately a legal question. My sense of things is probably a little bit more pragmatic than that. I think, Dr. Google, frankly, is a good starting place for a lot of us, particularly in today's day and age. It'll give you at least a sense of the broad issues. No one knows your family situation better than you generally, and then it's a question of trying to get that specialist advice. Generally, a financial advisor and or accountant would be the starting point, I think, because they would be the ones that could then overlay all of those parts of the puzzle and say, well, look, this is what we're seeing in similar situations. The actual final documenting of it can be done by the trustees unilaterally, and there'll often be template documentation in the establishment material. Or, as I said, a lot of lawyers would strongly recommend that you get legal advice, and that isn't so much necessarily just because of this BDBN, it's because of the way that it then interrelates to all the other aspects of the estate plan. I think there's probably three things that would have on that. The first one is not understanding that point we were just talking about. So in other words, understanding that it forms part of a holistic estate plan. So that means, proper wills, proper enduring powers of attorney, bloodline testamentary trusts, like all of the things that people probably hear about, but don't necessarily understand that they're all connected, and they should be all connected. So that's the first point. The second point is then not having a really deep understanding of what the specifics are for the actual trust deed itself. So, a lot of people they'll have a deed that the advisor's provided, but then they'll just, go to Dr. Google or whatever and get some other template binding nomination and just sign it because it seems like the right thing to do, without ever stopping and saying, well, does this template document actually fit with what the rules of my fund say? And then the third one it's actually two components to the third one. The third point is that in a lot of situations, people look at this stuff in a very linear manner. So say it's a couple situation, they'll only think about what if my spouse dies, and then that's all the binding nomination will deal with. Well, often that isn't actually the question that needs to be answered. Often the spouse will have already died, or there'll be an accident or whatever it might be. They both pass away, and then the BDBN can fail because no one ever thought about that next down the line. So that that is an issue from day one, but then it becomes an issue when people don't regularly review this stuff as well. It's not a set and forget is the really key point there. The reality is, we often have a mantra, and maybe it sounds a little bit too technical, but I think it's the right mantra to have in this space, which is read the deed. So everything to do with binding nominations, BDDNs, anything to do with any other form of nomination, so that there can be non-binding nominations, as we touched on, which are expressions of a wish to the trustee, which aren't actually enforceable against the trustee. All of those comments are predicated on people actually having a deep understanding of the trust deed. Now, the taxman, if you ask the taxman, he or she would say to you, well, you really need the trustees to be completely across the trust instrument. The reality is how big are they these days? They're 50, 100 pages long. Quite often the advisor won't be totally across it, let alone the trustee themselves. What that means then is, probably the biggest common trap is making assumptions about what those legal documents say, based either on past experience or just a guess, that turn out to be wrong. So I think, the real answer ultimately is to read the deed and to consider the binding nomination as part of that overall framework. But if it's not you as the trustee, even though the taxman says you probably should do it, employ the professional to get them to come in and do it for you.